a statement by Dr. Anthony Fauci about a week ago that basically Omicron, with its extraordinary, unprecedented degree of efficiency and of transmissibility, will ultimately find just about everyone. It's my understanding that as of Monday this week, 20% of Americans had had COVID. And although it may be possible that the new cases are declining, it is not a precipitous decline, it's a slow plateauing. And so this is an issue that is certainly an important one now and will be for at least several weeks to come. Just an update on things you probably know. The US Supreme Court on Thursday, January 13th, blocked the federal OSHA rule, which would have required either vaccinations or weekly testing by employers with 100 employees or more. California is a state planned jurisdiction and would not have automatically been governed by that federal rule. And the future decisions by Cal OSHA are being decided today at a meeting of the Cal OSHA Standards Board. It is unlikely that California will impose mandatory vaccinations as a general rule. However, we all have to keep our eyes open for what the OSHA Appeals Board Standards Board does. In the rulings of the US Supreme Court, they did uphold vaccination rules for medical employers who receive Medicare or Medicaid funds. And if you're an operation which that applies to, which could be home care agencies, facilities that care for the aged and so on, you need to be aware of that rule. If you're an employee of the federal government, federal branch, executive branch, departments of all the way from Interior to Agriculture to Health Human Services, those employees must be vaccinated or obtain an exemption. The exemption for that is the exemption that would be based on either a medical disability that prevents vaccination or a sincerely held religious belief. And in that case, an accommodation could be either work from home, quarantine, mask, we don't know, it would depend on the circumstance. There was a federal rule that would require federal contractors, companies, private companies that had contracts with the US government to do mandates, but that has been suspended by the court and is not active. So the implications of that Supreme Court ruling are, for most employers, you can decide your own COVID vaccination policies. You do not have to require vaccinations. California employers need to adhere to new Cal OSHA regulations, which we'll touch on briefly, which took effect January 14th. Hospital, nursing homes, related facilities must have 100% of staff vaccinated, and the first dose is due by January 27th, with all employees fully vaccinated by February 28th. California has extended its indoor mask mandate so that the California Department of Health requires that all people in indoor public settings, and that includes office buildings, factories, retail stores, must wear a mask through February 15th, 2022. And Los Angeles County has its own mandate in addition. I have been in a number of offices and so on in the last few weeks and noticed that there is not a universal observance of this policy. An employer could be cited by Cal OSHA or by the Department of Public Health for failure to follow this policy. The California Department of Public Health has issued guidance on December 30th, which included the somewhat controversial CDC guidance that was issued at the end of December. It deals with isolation and quarantine, which is not a big deal one way or another because removal from work is the issue. The governor has coordinated the California Department of Public Health guidelines with Cal OSHA. So although Cal OSHA rules were slightly different, they are not different any longer because by the governor's order, they are to follow the California Department of Public Health rules, and we'll talk about it. If there are local ordinances, and there are in the city of Los Angeles and the county of Los Angeles, and a number of San Francisco Bay Area counties, you need to be aware of what those rules are. Also, for these purposes, fully vaccinated now includes people who received not only their initial doses of vaccination, but a booster shot if they were eligible for a booster. Another part of this is the COVID test, because if people need to get tested because of company policies or to comply with the removal from work rules, which we'll talk about, a number of employers have been providing or getting employees take-home tests. The difficulty is if an employee doesn't go to a medical facility or pharmacy for their COVID test, and they use a take-home test, for it to be valid for an employer, it cannot be both self-administered and self-read unless it's monitored somehow. We think that one of the ways to monitor that would be on some kind of FaceTime use of a smartphone or some other manner. So simply having an employee send you a text message with a copy of a negative test from the take-home test doesn't cover, because it isn't watching how the test was administered. OSHA, as I said, has adopted its new rules that are effective January 14th, and these are in effect for the next 90 days and can be extended beyond that. Face masks, the one change is that if you have fabric masks, it needs to be 2 layers, and they have what they call a light test, which means you could show a flashlight and see. That does not mean light is totally blocked, but it does intend to show when there is loose weaves and fabric holes where the COVID could get through. Worksite does not include places where an employee works at home, such as remote or in their personal residence. The important thing, as I already said, was fully vaccinated has been updated. Some other parts of that are that if there is a report of employees who are exposed at work to someone with COVID, the employer must provide testing. Now, that's become a little easier because some jurisdictions, including Orange County, provide free tests upon request on the internet. The federal government is now active with having an ability to order up to 4 take-home tests at a single address. And as I will note in a minute, insurance companies are supposed to pay for reimbursement of these tests. Testing needs to be available where there's 3 or more employees in a high-risk environment during a 14-day period. Some of this you're already familiar with. Major outbreak is when there are 20 more employees in a 30-day period. Then employers need to make testing available twice a week, and there's a requirement that they be done on work time. If your employee can do a take-home test and do it from home, that will not include any particular time. Notices, I think, is not new, but you are aware if an employee was aware of a work site possible COVID contamination, you need to notify the other people at that work site within 1 day. And then you need to exclude people from the work site under certain conditions, which we'll talk about. California, Los Angeles County has issued an update of its order. So now it requires employees who work indoors in close contact with the public or other workers to be offered either medical grade surgical masks or N95s while indoor. And this order took effect on January 17th. There's a requirement for vaccination boosters for healthcare workers, and I'm not going to go into that, but just to remind you that that's a rule. One of the key issues now, because so many people are experiencing COVID, in terms of even 30–40% of the workforce, how do you exclude people in a COVID situation? And the California OSHA emergency regulator clarifies that when an employee tests positive or is exposed to COVID, they may not return to work. There are 3 groups of employees. So the rules are a little complicated, and I'm sorry for that, but it is. If people test positive for COVID, no matter whether it was work-related or from a family or social environment or whatever. They need to stay home for 5 days. They can end their isolation after day 5 if they don't have any symptoms and test negative. If they don't do that, then they need to stay out of work for 10 days. If they choose not to test, or the symptoms are not there, the symptoms have to resolve before they return to work, but they have to stay home for 10 days. If there's fever, it should be isolation continue until fever resolves. It requires wearing a mask when they return to work, but that's not a big deal because everybody's supposed to be wearing a mask. The second group of people are not people who have tested positive, but people who are exposed to COVID. And there are two groups here. If you're unvaccinated or not boosted, meaning within the time period, this set of rules applies, which means stay at home for at least 5 days after your last contact with someone who had COVID. Test on day 5, and quarantine can end after 5 days if the symptoms are not present and you test negative. If you don't choose to test or symptoms are not present, then you have to quarantine for an additional 5 days or a total of 10. If you test positive, then you go to table 1, the first group, and follow those rules. Third group are for vaccinated and boosted people in that were exposed to COVID. They don't need to stay home. They need to get a test on day 5 from the exposure, and they need to wear a mask. I would just tell you that the federal government has required health insurers to provide up to 8 at-home tests per enrollee in their health plans every 30 days. And that rule is now in effect. Some insurance companies have said, well, we're not ready for it. Well, they're going to have to get ready for it, and they're going to have to reimburse you. But normally, the same way they would reimburse any out-of-pocket medical expense covered by your plan. Then there's some questions about exclusion and exclusion, what we call exclusion pay. If an employee is excluded from work because of workplace exposure, meaning he got COVID from work or he was exposed at work, the person's entitled to pay if you didn't have them work at home or remotely, or they did not receive state disability insurance or workers' compensation benefits. Second part is, can an employer who required take paid sick leave because you have it? The Department of Industrial Relations and OSHA have determined that you can require them to use sick pay other than the 3 days per year called for those who work under the California paid sick leave law. So you can't just say you must use all sick leave to cover the cost of exclusion pay, but you can, if you have more than 3 days a year, you can have them use the excess. And realize in certain areas like LA County, LA City, Pasadena, and so on, they have a local ordinance that requires 5 days or more sick pay. Any of that time over the first 3 days can be used to satisfy the exclusion pay requirement. And the other part is you don't have to give exclusion pay if you can demonstrate that the employee's infection or close conduct was not work-related. Now, I've had folks say, well, how do we know that? My suggestion is you ask employees where they think they got COVID. If they say they don't know or they have some idea that's not work-related, then you can rely on that information. But this is kind of a close call issue, which can be significant. That's an update, and I was interested in making sure that we give you the latest on this subject. Okay, so Jake, I'll turn it over to you.
All right, and So next up, we have Kayla Washington. Kayla is an attorney and consultant with CalWorks Safety and HR. Let me go ahead and
Hello, everyone. My name is Kayla Washington, and I'm an attorney and consultant with CalWorks Safety and HR. Today, I'm going to go over employment posters and new hire notices. So first, I'm going to do a very brief overview of laws that may apply to your organization. Wanted to try and highlight some laws that apply to many small employers. So as you can see here, a majority of these laws apply to employers that have as little as 16 employees. A few here apply to all employers regardless of size. For example, some protected leaves of absence, such as crime or abuse victims leave, specifically in regards to the legal proceedings and reasonable accommodations. And then there's victims' rights leave, which both, of course, are applicable to all employers. There are many more laws on this page that apply to all employers, regardless of size, such as the requirement to have an injury and illness prevention plan. If you don't already have an injury and illness prevention plan, this is a service that CalWorks Safety and HR offers. So please contact your consultant to get one started. I also want to point out the lactation accommodation. So this is something that's typically in your employee handbook, or you may have a separate policy. This policy should be given to new hires if not in your employee handbook. And again, many of these laws apply to all employers regardless of size, such as paid family leave and paid sick leave, which I'll discuss a little bit later. And I know we went through these rather quickly. However, as Jake had mentioned before, the slides will be available and emailed to those that request them. So mandatory postings and penalties. You may be required to post additional posters if your business is located in a municipality that has passed local ordinances. This could address minimum wage or paid sick leave or other labor law requirements. So there might be additional posters if you have forklifts on your workplace premises, for example, or if maybe you're in an unincorporated area of LA County. They have typically higher minimum wage, so there might be additional posters for cities that fall under that area. So the posters must be in a place where they can be easily read by employees and in some cases job applicants as well. So typically it's the federal law posters that need to be in a place accessible to job applicants. Remote workers. So I know as COVID is spreading, we have a lot of workers working from home, working remotely. So they should still have access to these posters. Best practice is if you mail them to these employees and then they can hang them up in their work office, in their home office. So even if most of your workplace is remote, please remember you'll still want to keep your employment posters in the office. So there are penalties for violating poster requirements. It can range anywhere from monetary penalties to misdemeanors or imprisonment. So, for example, an employer who violates any provision of the Federal Employee Polygraph Protection Act of 1988, which is including the posting requirement, can face a fine of up to $21,663. So, wage order posters. California law requires you to post your Industrial Welfare Commission wage order in your workplace. So, there are 17 different types of wage orders, and in some circumstances, employers may need to post more than one order. So, if you have any trouble determining which wage order you believe applies to your company or whether or not you have to post multiple wage orders, you can always ask your CalWorks Safety and HR consultant. So our next poster is California law prohibits workplace discrimination and harassment. So this poster, like its title mentions, overall relates to the prohibition against discrimination, harassment, and retaliation. So this includes a prohibition against sexual harassment, gender harassment, harassment based on pregnancy, childbirth, breastfeeding, and or related medical conditions, as well as harassment based on any other protected characteristics. This also touches on the fact that employers with 5 or more employees and all public entities must provide sexual harassment training. So this is something that your company hasn't done in a couple years. Please reach out to your CalWorks safety and HR consultant so they can set you up with sexual harassment training. And this also has information on how to file a complaint with the Department of Fair Employment and Housing right at the bottom there. So the next poster is transgender rights in the workplace. So this poster provides the definition of transgender, describes what a gender transition is, their social and physical, and has some answers to frequently asked questions for employers. I would advise employers to take a look at the frequently asked questions as it can relate to dress codes enforced in the workplace or questions an employer may ask an employee, maybe during interviews or any other time during employment. Again, there's information on the side as to how an employee can file a complaint. Safety and health protection on the job. OSHA requires employers to post information on pertinent safety laws and regulations. Under California law, all employers must provide work and workplaces that are safe and healthful and must follow state laws governing job safety and health. So, this poster provides employers with information on contact the OSHA consultant as well, if they have any information or if you need any information or required forms. It has the numbers for Cal OSHA offices listed towards the bottom. Also, if you believe that you may need safety services, you can always speak again to your CalWorks safety and HR consultant. We provide safety audits to help determine your company's areas of opportunity concerning safety. This next poster is notice to employees injuries caused at work. So, this poster lets employees know that if they're injured on the job, they may be entitled to workers' compensation benefits. Goes on to describe the available benefits and the steps that should be taken if a worker is injured. Please note that this poster must be filled out in order to be compliant. You should provide your medical provider network. That's what MPN stands for at the bottom there. And along with your workers' compensation carrier information. So please understand that must be filled out in order to be compliant with the posting requirement. Access to medical and exposure records. So this poster is only required for employers that use hazardous or toxic substances at their workplace. It provides information about rights of employees working with those types of substances. And this poster needs to be filled out as well. Your rights and obligations as a pregnant employee. This poster must be displayed by employers with 5 or more employees. This provides notice to employees of the right to request pregnancy disability leave. So, pregnancy disability leave is a leave up to 4 months for the period of time that an employee is considered disabled by pregnancy, childbirth, or a related medical condition. So, this leave does not have to be taken all at once and can be taken intermittently, as described on the poster. And again, it has information there on how an employee can file a complaint. Our next poster is family care medical leave and pregnancy disability leave. So this must be displayed by employers of 5 or more employees and all public agencies. This provides notice to employees of the right to request California Family Rights Act leave. And this kind of ties into pregnancy leave because typically this CIFRA leave is often taken for baby bonding after employee has delivered their baby and typically completed their pregnancy disability leave. So, CIFRA is job protected leave for up to 12 work weeks in a 12-month period for applicable employees to take because of birth, adoption, or foster care placement of a child, their serious health condition, or that of a close family member, as well as some military qualifications under this leave. The next poster is the Whistleblowers Are Protected poster. So, whistleblowers, typically an employee discloses information to a government or law enforcement agency, person with authority over the employee, or to another employee with authority to investigate, discover, or correct a violation or noncompliance. So, this could be your company's investigative officer or your safety compliance officer. This lists an employee's rights under whistleblower laws and includes the telephone number of a whistleblower hotline, which is maintained by the Office of the Attorney General. That's found right on the bottom there. So please be aware with this poster, it must be larger than size 14 type. So if this poster is printed on an 8.5 by 14-inch paper with margins about 0.5 inches, that should hit the compliance for the size 14 type. This one's a notice to employees regarding unemployment insurance benefits. So this lists some information on unemployment insurance benefits and how to file. And then it has some phone numbers at the bottom and how to file online. Time off to vote. The California Secretary of State requires employers to post information regarding an employee's right to take time off to vote. So, this must be posted at least 10 days before a statewide election. Best practice is to just always have it up so that way you don't forget to post it in your workplace. Emergency phone numbers. Again, this is another poster that must be filled out in order to be compliant. So this can be posted by your main company telephone. The statute reads a telephone switchboard, which I feel is a little bit out of date, or it could be otherwise made to the employees where no job site telephone exists. Then the no smoking allowed sign. This sign should be posted to designate that smoking is not permitted in areas of the workplace. Payday notice. So this poster has information regarding paydays. Again, this must be filled out in order to be compliant. You'll want to put your payday, the time that an employee can expect to be paid, and maybe the location. Maybe it's at one of your offices as opposed to all offices, like a corporate office. Please fill it out. A lot of the times, employers think that just posting these posters is enough. However, they do need to be filled out with the correct information. Notice to employees of unemployment insurance, disability insurance, and paid family leave. This should be posted in the workplace as well. And I'll touch a bit more on disability insurance and paid family leave later once we get to new hire notices. Paid sick leave. This provides information to advise employees of their sick leave rights. So, this basically describes that an employee who works 30 or more days within a year from the beginning of their employment is entitled to paid sick leave. So, if you're following the accrual method, then paid sick leave will accrue at the rate of 1 hour per 30 hours worked. And overall, you must provide employees with no less than 24 hours, or if it's full-time employee, 3 days of paid leave or paid time off. So again, this poster, this is applicable to all employers regardless of size. California minimum wage. Employers are required to post information related to wages, hours, and working conditions. So you'll want to have this poster displayed up in the workplace. Now going to required federal posters. Sorry about that. So you'll want to display the federal minimum wage poster as well. So even though you are required to abide by California minimum wage or your local minimum wage, if that's higher, you'll still want to post this up in your workplace. This is still required even though you're not following, not paying your employees the federal minimum wage. So equal employment opportunity. This lists which categories are protected from discrimination under federal law. So we have race, color, religion, sex, national origin, genetics, disability, age, sex as it regards to wages and the Equal Pay Act, and what to do if you believe you've been discriminated against. And it has some more information here for employers holding federal contracts or subcontracts. So that's important to note as well. Our next poster is Family and Medical Leave Act. So this is required to be posted by employers of 50 or more employees and all public agencies. So you may be familiar with this. This provides eligible employees with up to 12 weeks of unpaid leave. This could be for the birth and care of their newborn child, placement with the employee of a child for adoption or foster care, caring for an immediate family member that has a serious health condition, or to take medical leave when the employee is unable to work because of their own serious health condition. This and the California Rights Act leave are very similar, pretty much a state and federal version of the other. And this summarizes the major points of that leave and also has the number to the US Department of Labor if there is an employee, if an employee wants to complain. So there we have on the federal posters the Department of Labor number, which is different than our California posters, which had the Department of Fair Employment and Housing. So this next poster is in regards to veteran benefits. So this prohibits employers from discriminating and retaliating against past and present members of the uniformed services. It also discusses some reemployment rights and of course discrimination retaliation, as I mentioned. Then it also has the phone number to the US Department of Labor if an employee wants to make a complaint. So the Employee Polygraph Protection Act poster. This informs employees that most private employers are prohibited from using polygraphs, lists the information given, and the US Department of Labor's phone number. So as this describes on the bottom and kind of what I touched on earlier, the law requires employers to display this poster where employees and job applicants can readily see it. So going to pamphlets and notices, various state laws and federal laws and regulations require you to distribute notices and informational pamphlets to employees. Some are distributed at the time of hire or termination, and some notice requirements are triggered by certain events. So, in addition to the typical I-9, W-4, and state tax withholding forms, the following documents must be given to a new hire. So, we're starting off right here with notice to employee. This is required to be given to all non-exempt employees. Non-exempt employees are typically your hourly employees who are not exempt to overtime requirements. So you'll need to input all of the company information there where it reads employer, the wage information, the rate of pay. Make sure to fill out all the information on this form. It's 2 pages. Then you'll want to fill out your workers' compensation and the paid sick leave. You'll want to include whether it's on an accrual basis and how your company provides paid sick leave, and you'll want the employee's acknowledgement of receipt. Disability insurance provisions. So, this is a little pamphlet that you give out to your new hires. It's required to be provided to all employees. This provides the definition of disability, disability insurance, and it also provides information on how to file a disability claim, as well as how benefits are paid out, how their benefit rate can be determined, their rights and obligations. So this is typically printed front and back, and then it can be folded up into a little pamphlet so you can distribute that to your new hires. Rights of victims leave. So this describes an employee's right to take time off to obtain relief from the court, including obtaining restraining order to protect an employee or an employee's child's health, safety, or welfare. So that is required for all employers to allow employees to take that leave. It also goes on to describe that employers with 25 or more employees must provide time off from work to get medical attention for injuries caused by crime or abuse, receive services from a domestic violence shelter, program, rape crisis center, or victim services organization or agency as a result of the crime or abuse. They are also allowed to take time off to receive psychological counseling or mental health services related to an experience of crime or abuse, or participate in safety planning and take other actions to increase safety from future crime or abuse. Again, that's only applicable to employers with 25 or more employees. And right here, it also has that an employee has a right to be free from retaliation and discrimination for taking their right to victims leave, and information on if they want to file a complaint with the Labor Commissioner's office. We have a time of hire pamphlet. This is about 8 pages long. Describes workers' compensation benefits and what workers' compensation is. So it lets an employee know that one event at work can cause a workplace injury, something like falling off of a ladder, as well as repeated exposures at work. For example, at carpal tunnel. It lets employees know that they may file claims with the EDD for disability benefits as well if their workers' comp benefits are delayed, denied, or have ended. That's at the bottom of this page. Then this third page should be filled out with your own workers' compensation insurance information. This one should be filled out with the facility that you take injured workers to. So that way, when an employee is injured, they're aware of the hospital or clinic that they should report to. This bottom portion should be filled out, and you have to fill in the closest information and assistance unit. So you can figure out which is the closest to you by going to the dwc.ca.gov webpage. So not only will this help you figure out the information and assistance unit, but it's really just has helpful information on workers' compensation in general. This is some more additional information for employees. And this form is one that an employee will fill out and provide to you to notify you that they wish to have their personal doctor treat them for a work-related injury. And this notice is to notify you of a personal chiropractor or personal acupuncturist that an employee may want to use. So additional information that must be given to a new hire is the sexual harassment fact sheet. So this must be provided to new employees. It describes the two types of sexual harassment, quid pro quo, and hostile work environment. Goes on to describe the different forms of offensive behaviors that may be considered sexual harassment. It also has the employer responsibilities and liabilities, which is such as taking reasonable steps to prevent the harassment. The second page outlines what actions employers must take to prevent harassment and what to do when it occurs. So, this could be distributing copies of the brochure, posting the California law prohibits workplace discrimination and harassment poster, which we touched on earlier, developing a harassment, discrimination, and retaliation policy. So, if your company doesn't currently have a harassment, discrimination, and retaliation policy that you know of, please reach out to CalWorks Safety and HR so that way they can get you started with one. So paid family leave. This is another brochure. Would be a front and back brochure that's kind of folded up into a trifold pamphlet. This must be given to new hires as well. California offers paid family leave, which is a program that offers benefits to employees who take a leave to care for a seriously ill family member, to bond with a new child, or participate in a qualifying military event. So, this program provides up to 8 weeks of partial wage replacements, which is 60 to 70% of wages. And then the second page here describes how someone can qualify for California paid family leave and how the benefits are calculated. So, just a reminder, these are not employer provided benefits, these are benefits provided by the state. Another form that you'll have to give to new hires is the new health insurance marketplace coverage options in health coverage form. So, under the Affordable Care Act, employers covered by the Fair Labor Standards Act are required to provide a notice to employees about the health insurance marketplace exchanges of the state in which they operate. So, there are two different models of this form. One is for employers that do not offer a health plan, which is here, the one that I'm showing on the screen. And there is another model for employers that offer a health plan to either some or all of their employees. So again, this form, the first page is general information, the second page, and it's pretty much the same on the form where it's employers that offer a health plan to some or all employees. You're going to have to fill out some information here before providing it to the employee. There's also a general notice of COBRA continuation coverage rights. If you get the model general notice off the Department of Labor website, has a helpful introduction to help get you started as to how to fill out the page. And it also describes an employee's rights to COBRA continuation coverage, when it may become available to an employee and their family, and what they need to do to protect their right to get it. So this general notice of COBRA continuation coverage rights is only required if you have 20 or more employees and if you offer a health plan. So this is a pretty long document as well. There's some parts that you'll need to fill in, So for instance, the paragraph close to the top, if the plan provides retiree health coverage, add the following paragraph. That'll need to be added in there. And then any other coverage options besides COBRA continuation coverage. And if they have any questions regarding their plan. So that concludes my presentation on the employment posters and new hire notices. Please contact CalWorks Safety and HR if you need any of the documents that were described in the slideshow, and we can provide them to you. Thank you.
Great, Kayla. Thank you so much. We have just enough time for some questions here. So let me just scroll up here for a sec. Okay, first question. If there is an exposure at a retail setting, do customers also need to be notified?
No, there's no requirement for notice to customers. The notice requirements are under the OSHA law, which apply for employees.
Okay, and next question. Are there any privacy issues employers should be aware of when monitoring an employee home test?
There's not a privacy issue when they're monitoring the home test. There is a privacy for your records of test results or your records of who is vaccinated or not vaccinated, which means they should only be shared with company personnel who need to know, not generally available to everybody.
What is your opinion on cloth masks versus paper masks, N95 or KN95?
Well, since masks are going to become available and even perhaps they're available to the general public from the federal government, I have worn cloth masks. If they're multi-layers and they're tightly woven, they're valid, but it is sometimes easier to use what we call the blue surgical mask because that does qualify. And but there's certainly nothing that prohibits the use of a multi-layer cloth mask.
Just to clarify, masking is required in office setting only when you are within 6 feet of others. Is this correct?
No, you have to wear a mask anytime. The only exception is if you're alone in a room where the door is closed. So if you're sitting in a private office and the door is open, you must have a mask on. Now, you don't have to have a mask when you're eating or drinking. But other than that, the social distancing rule doesn't preclude the requirement for wearing a mask.
Should employers have written waivers from employees to monitor a home test?
I think that how you're going to handle monitoring a home test depends on what technology you have and what technology your smartphones and so on your employees have. So I don't think I can give a general answer to that, but I can suggest that. And also, an employee can't waive this. This isn't an issue for employee waiver. This is an employee, the OSHA requirement. So I suggest you talk to a consultant or think through how you're going to handle documentation for your operation.
Are tests inclusive of at-home rapid tests or restricted to PCR?
Any of the tests that are approved by the Food and Drug Administration are allowable, and that does include most of the commercially available at-home tests. There are apparently some pop-up distributors on street corners and so on that may be selling tests that are not FDA approved, but all of the regular, reliable commercial vendors, pharmacies, and so on, Walgreens, CVS, have valid, appropriate take-home tests, or most of those with their pharmacy can also do tests in the store.
Okay, and this one. I assume my 2022 all-in-one poster will contain all of this required information.
That's a good question, and actually, we have a small sample from the first deliveries of posters, and we have hundreds of posters on order, both English and Spanish, for those of you who have Spanish-speaking workforce. Any retainer client of our firm will be getting a set of posters for their one set. If you have multiple locations, or if you're not a retainer client, we can identify for you low-cost providers, and we can also provide them to you at our cost. But we want to make these posters as available to our clients as we can. The consultants you work with will be in touch with you to provide them. I hope we have our full supply of posters by next week. We have a limited supply now, and we're printing hundreds of posters, both in English and Spanish. And thanks to Combined Benefits Insurance Agency that's helping pay for part of the cost of these posters.
If an employee tests positive, can boosted coworkers who did not come in close contact continue working without quarantining or getting a test?
Yeah, the exclusion rules apply if you have what we call close contact, which means that you work within 6 feet or more of a person who's tested positive for 15 minutes or more. The notice requirements that somebody had COVID in your workplace mean that you need to make testing available, but doesn't require exclusion itself. So if you don't have COVID, the test is close contact, which is the 6 feet or more, 15-minute rule.
All these posters need to be posted in Spanish and English, correct? I don't believe we have this much wall space.
I agree. I got my first set of posters myself yesterday. You don't have to put Spanish if you don't have primarily Spanish-speaking employees. We also have available electronic versions of these so that you could post them on some electronic site, website, or employee information site. That's also a way to communicate posters to workers who are working from home, so that you can actually send an email attachment with the posters. If you'll note it in a request to us at info@calworksafetyhr.com, we can help with that. We have obtained electronic versions of these posters, both English and Spanish.
Any laws we should know about rehiring indigent or homeless who have ID?
A person who's indigent or homeless has no particular status. It's not a protected status under the employment laws now at this time, so that you can have them follow the same review, application, and hiring decisions as any other employee. They're not exempt from it either, because hiring is hiring, whether it's an exempt employee, an hourly employee, a temporarily unhoused person, or somebody living in their car. The rules are the same, and the same new hire forms need to be completed, including an I-9 form.
Do employers have to pay 100% of exclusion pay when an employee refuses to apply for SDI and has no sick beyond 24 hours?
If a person is eligible to apply for SDI or a workers' comp benefit, that now satisfies the employer's obligation, even if they choose not to file it. If they're not able to file for SDI or workers' comp, and realize now SDI has a 1-week waiting period. Last year, they eliminated that 1-week waiting period, but that 1-week waiting period is now reinstated. You can use paid sick leave above the 3 days a year, but other than that, you do have an obligation to pay. Fortunately, that only applies if the person is exposed from a work-related reason. And my experience has been 90% of the cases our clients have had have been non-work-related exposures. So I think that's it. Just to once again, if you want a copy of the presentation, please send an email to info@calworksafetyhr.com, and we'll be glad to provide both the COVID rule and the a notices poster. And also we will be posting this on YouTube, on the YouTube channel, CalWorks Safety. I don't know, Kayla, if you saw, how many posters are there?
We got another question here. Are boosters mandatory for all healthcare employees as of February 1st?
I don't know the answer to that. I know that that shot vaccine is necessary under California order. You have to check with the Department of Public Health on healthcare workers, or send an email and we'll research that and get back to you.
Should copies of vaccination cards and COVID tests be kept in employee confidential files?
Well, since you need to know who's vaccinated or not for exclusion purposes, I would suggest that you'd want proof that you did do the investigation. It's not a legal requirement to maintain copies, but it seems to me it's a practice that makes sense.
Great. And we have one last question here, it looks like, for Kayla. Do you know how many documents there are that need to be posted? Just curious.
I did a very quick count right now, and it looks like it's about 24 or so. And that also, like I said, that depends on what city you're in or county, or what type of business your company operates, as that may go up.
All right. Do we have any more questions? I think that's all. Thank you for sharing, guys. This is an important topic. And remember, if we didn't address your questions today, go ahead and reach out to us at info@calworksafetyhr.com for a copy of the slides or a recording of the presentation today. As a reminder, CalWorks Safety and HR is dedicated to helping businesses remain compliant and successful during the COVID-19 pandemic. Again, please be on the lookout for future topics on our website at calworksafety.com. Thank you for joining us. Stay safe, healthy, and have a wonderful day.